Hello and welcome to our first lecture of week 7 on the contract clause. I have combined two chapters in our text into week 7 because they are so closely related to each other. The contract clause and substantive economic due process are two very closely related concepts, and they both have to do with state regulation of economic rights and economic interests and transactions. So we are shifting here from talking solely about commerce in terms of the federal government regulating commerce to states regulating intrastate commerce and intrastate contracts. So let's get started. All right, so in terms of an overview of contracts, Article 1, Section 10 states that no state shall pass any law impairing the obligation of contracts. Important thing to note, there is no similar specific prohibition against the federal government. It's only applied to the states. So this is meant to protect agreements between private parties from state interference, and it was also meant to protect agreements between private parties and states. So when a state enters into a contract with private individuals. Now, why would this be in there? Why would the framers of the Constitution limit the power of the states in this way but not apply it to the federal government? One of the arguments that the anti-federalists made was that state governments should be empowered to interfere with contracts and to interfere with economic arrangements to benefit the least advantaged classes in a state. In other words, those people who would feel the effects of economic downturns most profoundly. We know actually that this is precisely what led Daniel Shays to rebel against the state of Massachusetts and led to an armed uprising, and ultimately a lot of people becoming very concerned and then calling for a new constitutional convention. So Article 1, Section 10 includes this prohibition against state interference with contracts. So thus states can't interfere to benefit any class. They're not supposed to benefit the most advantaged classes, and they're certainly not supposed to interfere for the benefit of disadvantaged. And the reason this went in there was because there was a sense among the framers that the rest of the Constitution was going to stabilize the economy in such a way that many people would get rich, and we wouldn't have to worry so much about an underclass, and thus there would be no need for states to interfere with contracts on behalf of the poor, and we certainly didn't want them to interfere in contracts on behalf of the rich either. Either one of those, according to the framers, was the simplest definition of tyranny. So let's talk about some early cases. The Federalists gave us, as in many cases, throughout this course, the Federalists, and in particular Chief Justice John Marshall, gave us our initial definition of what these clauses of the Constitution mean. And they endorsed the importance of contract rights over public good. In other words, they wanted to preserve the rights of individuals to contract without state interference, even where the state interference was based on preserving the public good and order. So the reason they did this was because John Marshall and his fellow Federalists saw rights to private property and private contracts as natural rights. In other words, God-given rights, those same kind of rights that we find in the Declaration of Independence. And the Constitution attempted to preserve those and protect those from state interference. Also, the Federalists really wanted to limit state power. They were interested in empowering the national government to spur economic development, that the national government would be the engine of economic development throughout the nation and not the states. That's not exactly how it turned out initially, but that's what the Federalists wanted to achieve. So we're going to look just briefly at two cases that are mentioned in the chapter. and discussed in the chapter. Fletcher versus Peck was a case involving a corrupt land deal made by the Georgia legislature. Now, the Georgia legislature sold thousands and thousands of acres of publicly owned property on both sides of the Yazoo River for pennies, and they sold these acres to individuals who they wanted to pay off for putting them in office. These individuals turned around then and made private contracts. In some instances, they made private contracts with other individuals who had not been party to this fraud, these were they were innocent in it, and they got charged a full amount so that these cronies actually made a good deal of money. One of the individuals who engaged in this kind of transaction, who bought property from the corrupt cronies of the Georgia legislature, was John Marshall. So yeah, he was intimately involved in this. He and his brother purchased property. So when the people of the state of Georgia found out about this, that their legislature had basically raided the public trust to pay off some people who had put them in office, at the next election, they booted out over 90% of the members of the legislature. There was a 90% turnover in the Georgia legislature because they saw all of them as corrupt, and they were right. The new legislature comes in and they say, we're rescinding this deal. We want all our land back. But they didn't just take the land that was still owned, that hadn't sold yet, that was still owned by the cronies. In other words, the people who had contracted with the state. They didn't just take that land back. They also tried to get the land back from the people, the innocent people who had bought some of the property from the cronies at full price. And so these people sued. And the Supreme Court heard this case, and Chief Justice Marshall says, yes, the Georgia legislature can rescind the contract with the cronies, but they may not interfere with the contract that those cronies made with these innocent parties who had paid full price for the property. In other words, states may not set aside private contracts even for a public good. So we see there actually that contract is more important than stopping fraud in some cases. Dartmouth College is very much like this case. It involves state interference in a private charter or corporate charter. Dartmouth College had received its charter from the British Crown, and at the time there was not a clear understanding of what these corporations were and how they should be treated under law. John Marshall gives us our first look at that. He says, a corporate charter is a contract, and thus it must remain free from state interference. Now, the state had attempted to jump in and take over Dartmouth College and set aside the private charter and get rid of the old board of trustees and put in its own trustees. And the old trustees sued the state for interference in the contract. And they won. They won, and thus now corporations are, have a special legal standing, just like individuals, and corporate charters are contracts that must remain free from state interference. So these early cases really land on the side of private contracts over state power. Well, as we know, when John Marshall dies in office, President Andrew Jackson appoints Roger Taney to be Chief Justice. And one of the cases that he hears in his first couple terms is proprietors of Charles River Bridge versus the proprietors of the Warren Bridge. In this case, the legislature of the state of Massachusetts had given a contract to the Charles River Bridge Company to build a bridge across the river there in connecting Boston and Charleston. And this bridge would serve as a public means of access across the two towns, and the Charles River Bridge Company would be able to charge tolls for the use of the bridge. Well, the population in Boston exploded, and these people got very rich off of charging their tolls for crossing the river. But the population explosion also meant quite a bit of crowding and traffic backing up on this bridge. So after a while, the Massachusetts legislature in 1828 incorporated the Warren Bridge Company and authorized them to build a bridge about 100 yards away from the Charles River Bridge. And this company would build the bridge. They would be allowed to collect tolls to pay for the expenses of construction, plus they would achieve an agreed upon profit, and when that was done, the state would take possession of the bridge and people could cross the bridge for free. Of course, everyone's going to be using that bridge and hardly anyone's going to be using the Charles River Bridge and paying the toll. So the Charles River Bridge Company sues, saying that the Massachusetts legislature is abridging the contract that it had made with them. And the question is, does the act of the Massachusetts legislature to build this second bridge violate the contract clause of the Constitution? Are they violating the contract that they already had with the Charles River Bridge Company for the exclusive right to have a bridge across the river? Tawney says no, it doesn't violate the contract clause. Now you can see where Chief Justice Marshall would have said yes, right? Like, how is this different than the contract, the corporate charter that Dartmouth College has? But Tawney says no. And we see the pendulum shifting toward state power. He says, there is no exclusive privilege given to one company over the waters of Charles River, and the proprietors have no right to erect another bridge themselves or to prevent others from erecting one. If any of these rights are in contract, they must be explicit rather than inferred. So he gives a very narrow interpretation of this contract, and he says, if you read the terms of this contract, it's not exclusive, no matter what everyone else had thought for close to 70 years. It's not explicit, and the state is free to enter into another contract. So he sides with the state. All right, now we jump forward to a case in the 1930s that occurred during the Great Depression. And in this case, the state of Minnesota had passed laws governing contracts for a home loan, for home loans, mortgage payments, given by banks that were incorporated within the state. So states actually were also attempting to address problems associated with the Great Depression and give people relief. The law that the state of Minnesota passed allowed people who couldn't make their mortgage payments to put those payments into abeyance for up to 2 years. And they would have to pay the principal and the mortgage and some fees, but they wouldn't have to pay the interest. And none of these terms were in the actual contracts that people had entered into with banks. The state of Minnesota just interfered with the contract and basically put new provisions in that no one had agreed to. Certainly the banks hadn't agreed to, and so they sued. And the question was, does the Minnesota Mortgage Moratorium Act impair contracts between mortgage companies and homeowners in violation of the contract clause? Well, very much like Roger Taney, the Supreme Court during the New Deal votes that no, Minnesota has not violated the contract clause, and they side with the use of the state power. Why? Well, an emergency existed, an economic emergency, and the law addressed a legitimate end, which was to provide relief, reasonable relief to homeowners who could not make their mortgage payments during a time of economic crisis. And the reasonable and legitimate end there was to ensure that people were not turned out onto the street and that they could continue to make payments later when they recovered and keep their home. It's public order and public welfare and safety. Okay, so that's a very short introduction to the contract clause and the chapter. The chapter itself is quite short. Please have a close look and we'll move on to talk about government neutrality and economic due process, substantive due process.